Hello, hello. Okay, wonderful. We are back from lunch. Apologize for that brief technical difficulty. And Mr. Coachman, looks like we have got our second to last technically, agenda item. So let's move on to data privacy. Mr. Co-Chairman, do you want to maybe give a little background on this, or what are you thinking?
Yeah, absolutely. And we do have a couple of different things to talk about. We have another memo from Ms. Wangan that will kind of get at some of our earlier discussion on name, image, and likeness under this, but we don't have a bill associated with that yet. So it's just a bit of background that Ms. Wangan can provide us with that gets to our discussion of what's out there with ownership related to data, celebrity, and the name, image, likeness concept that we wanted to explore. We have the bill draft that we looked at last time, and we did a little bit of upgrade work. So, perhaps having Mr. Hopkinson walk us through the changes on 25 LSO 88 relative to what we saw before. That's on the data privacy government entities legislation. And so that's privacy rights with regard to data collected by the government of Wyoming on the citizens of Wyoming. That's the focus of that bill. And we were trying to provide some protections there. So there are some updates there based on the conversation we had in the last committee meeting and working through some of the issues that arose. And then the final discussion point, Representative Singh raised an interesting piece of legislation out of Colorado that passed this last year, which is House Bill 24-1058, to talk a little bit about protection that was added to their consumer privacy protections related to biological information, I think it was called, and talk a little bit about that issue and maybe whether that's something that we should incorporate into our consideration. So, Mr. Chairman, we've got a few things to talk about on data privacy. Maybe there are some other ideas from the committee, from our team online that we might want to go over, but I think, up to you, Mr. Chairman, but maybe hearing a little bit about the name, image, and likeness at the top with the memo might be a good way to start, and then we can get into the data privacy bill if that's what we want to do.
Mr. Co-Chairman, I think that makes sense. Let's just go ahead and maybe tee us off with that memo if you're feeling up to the task.
May I proceed?
Please do.
Thank you, Mr. Chairman. For the record, Emily Wangan, Legislative Service Office, Legal Division Intern. I'm here to talk to you a little bit about name, image, likeness protections in state laws. Many states have created penalties for using a person's name, image, or likeness without the person's consent. I've provided 3 examples of these laws in the memo. California's law has been on the books since the 1970s and provides that a person who uses another person's name, voice, signature, photograph, or likeness without their consent may be liable for damages. Those damages are detailed on page 1 going into page 2. And then, as we discussed yesterday with the deep fake legislation memorandum, there are some exceptions for news and sports broadcasting, political campaigns, and broadcasters of advertising content. Florida's law prohibits a person from publishing, printing, displaying, or otherwise using the name, portrait, photograph, or other likeness of a natural person for trade, commercial, or advertising purposes without written or oral consent. And the law defines who's eligible to give consent for the use of somebody's likeness. A person whose likeness was unlawfully used or that person's representative may bring an action to recover damages for any losses or injuries sustained from the use of their likeness. And that would include an amount that would be a reasonable royalty fee, punitive or exemplary damages. But if a person is a member of the armed forces, on top of those damages I just mentioned, there would be an additional $1,000 penalty imposed. And the exemptions are similar as California's. New York has a couple laws on this subject. One that creates a right of privacy with criminal and civil penalties for violating that right. A person, firm, or corporation that uses a person's name, portrait, picture, likeness, or voice of a living person without the written consent is guilty of a misdemeanor. That person, firm, or corporation may also be sued by the person whose name, portrait, picture, likeness, or voice was used without their authorization. A successful plaintiff would be awarded equitable relief such as an injunction on the use of their likeness, as well as damages for any injuries sustained as a result of that use. A jury may also award exemplary damages to a successful plaintiff if the defendant knowingly used the person's likeness without authorization. Before I continue on to college athletes, I would take any questions.
Mr. Coacham, please.
Thank you, Mr. Chairman. And Emily, thank you very much for this information and background. I think you mentioned in California, the exception for political campaigns, connected with political campaigns. Are the same exceptions in place for, I think it is for Florida, is it also for New York that political campaigns would allow the use of somebody's image?
Ms. Wangan?
Thank you, Mr. Chairman. I'm not sure off the top of my head. I do have the statutes in Appendix A.
Yeah, I didn't dig through and can go through, Mr. Chairman, and take a look. My curiosity there was if there was any understanding of how it's handled. That is a curiosity that I had, where getting into the conversations we had yesterday about free speech as it relates to elections and candidates. I was curious whether the fair use aspect of a political candidate's image would contravene the statute, but it sounds like, well, either there may be an exemption or maybe we don't have that level of understanding yet. Is that right? Do you have any sense of that for New York?
Ms. Wangan?
Mr. Chairman, I do not. That is something I'd be happy to follow up on, though.
Yeah, absolutely. That sounds good. Anything on that? I was going to switch.
Well, maybe just, Ms. Wangan, as I read this memo, for example, take Florida. In that first sentence, or active purposes, without the person or their authorized representatives written or oral consent, a person whose name, portrait, photograph, or likeness has been unauthorized used in the section, authorized representative may seek to enjoin the publication and recover damages for loss or injury from its use. So were you able to kind of discern if this includes public spaces? So I'm walking down the boardwalk, whatever, I'm in the background of a photograph. Would that mean, and it gets published, I don't know, in some trade association, whatever. Does that mean I'm entitled to enjoin for damages under the statute? Were you able to get a sense even in those public spaces? Ms. Wangan?
So, Mr. Chairman, in the Florida statute specifically, there's an exception in subsection 4C. Any photograph of a person solely as a member of the public and where such person is not named or otherwise identified in or in connection with the use of such photograph. So in that example, where you're walking down the boardwalk somewhere and you just happen to be in the background of the photo, I don't believe that would be actionable, as long as they didn't say here in the background is Representative Western. If you're just solely as a member of the public in the background, wouldn't be covered.
And so one follow-up up along kind of a little bit different lines, Ms. Wong, would be, where it says, use in the connection or resale or distribution of literary music or other artisanal productions, et cetera, et cetera. In any of these statutes, it seems like kind of the common denominator is without express consent. So I think the concern is that with big social media companies, Facebook, Instagram, et cetera, the gambit is that because you signed the terms and use agreements, all your photographs of you that you uploaded, that you took yourself, but they own, that's all fair game for them to use. Is that a fair understanding, or am I off base on that?
Mr. Chairman, I am not really sure how, signing a terms and conditions of a social media company would interact with these laws. I think there's a little bit of giving your consent in that form when you're signing terms of or agreeing to terms and conditions, that they may use your images, which would, if it was an image of yourself, would be your likeness. That would, I think, depend on the terms and conditions that the user agreed to when creating an account.
Thank you. Any members, Mr. Co-Chairman?
No, Mr. Chairman, not at this time. I'm still curious how New York handles elections. I was just trying to see if I could find it in there, and I didn't find it quickly, but
They have had a couple extra 100 years. They have had a couple extra 100 years compared to us to get their green books nice and full.
Right. fill them up.
Yeah.
Mr. Chairman, I guess I do
Mr.
have one
Co-Chair.
more question on this part. And Ms. Wongan, you may not know, but is there substantial case law associated with this, or substantial use in Florida or California or New York of these statutes being enforced? Did you see a lot of activity around them, or are they seldom used?
Ms. Wongan?
With Mr. Chairman, the California law has been in place for almost or more than 50 years. So there's been a fair amount of case law. I know on that one, there have been some issues decided before the courts on whether or not it is superseded by federal copyright law. And there's been some distinctions between when this statute can be used or when it's superseded by federal copyright law. And it's generally, the distinction is whether or not the person depicted has copyright rights to the image. But if you would like more information on that, I'd be happy to look into that a little more.
Yeah, that's interesting. Mr. Chairman, can you expand upon how that ends up getting interpreted? And I guess here's what I'm wondering about: where I establish a copyright, I take a picture of the co-chairman under the statute, and maybe I write an article about it or something. I basically try and establish some copyrightable circumstance. So we'll say I read a journalism piece about it. How is that then handled? Is that my copywritten photograph, or is that his image and likeness protected under California statute? Again, assuming we're in California and that California law applies.
Ms. Wongan?
Mr. Chairman, Mr. Co-Chairman, in that instance, I think that would be part of bona fide news reporting. So I don't think that would be subject to this law
I see.
anyways.
Does it explicitly, Mr. Chairman, does it explicitly
Mr.
say
Chairman.
for commercial use in the California? I think it does in the Florida.
Ms. Wongan?
Mr. Chairman, yes, it's for in any manner or on or in products, merchandise, or goods, or for the purpose of advertising or selling or soliciting purchases of products, merchandise, goods, or services.
Okay, so you have to have that commercial use. Okay, thank you, Mr. Chairman. That's helpful.
Any other questions for Ms. Wongan, or was there more on you want to,
On the other ones, yeah.
I think we got,
What is it? College athletics.
yeah, that's right, college athletics, that's right. Ms. Wongan, please continue.
Thank you, Mr. Chairman. Before I move on to college athletics, I did forget one section. New York's law about using a personality or a deceased personality or performance likeness after their death. It just protects, a celebrity who at the time of their death was domiciled in New York, New York State, just has some protections for their name, image, and likeness after their death. But on the subject of college athletics, many states have enacted laws regarding a college athlete's ability to earn compensation off of NIL deals since 2021. These laws generally prohibit a school or a governing body over college athletics, like the NCAA, from unreasonably limiting an athlete's ability to participate in NIL deals and seek and retain representation. If there is not a state statute, I believe the university itself is allowed to make policies that govern this. But there are some exceptions to allow schools to prohibit certain activities. I know in Tennessee, there is an outright prohibition on participating in NIL deals that promote gambling, tobacco, alcohol, or adult entertainment. There are other states that have a few more things such as marijuana products or things of that nature. In Oregon, however, if a athlete is not engaged in team activities when they are appearing in this advertisement, they would be able to participate in advertisements that might conflict with team rules. And there's no prohibition on when that advertisements could be broadcasted. So an athlete could appear in an advertisement for a product going against the team rules as long as they created the advertisement outside of like a game or a practice or something like that. Universities are also generally permitted to make campus-wide policies that would not just apply to athletes. So, a university could say all students are not allowed to participate in NIL activities relating to a certain topic or something like that.
Mr. Co-Chairman.
Did any of the statutes do anything to provide more rights to any of the students, or were they all restricting rights from the students?
Ms. Swangan?
So, Mr. Chairman, these laws generally provide for a right for an athlete to enter into deals with companies to use their name, image, or likeness, and it generally prohibits the school or the governing body for athletics from infringing on that right within limitations. There are also some requirements that athletes need to disclose any NIL deals with their university, but it's generally more making prohibitions on the university or governing body's activities.
Interesting, Mr. Chairman.
Mary, Mr. Co-Chairman, please.
This isn't a problem that I've heard we have, and it'd be interesting to talk to the university and see if there's anything that would be beneficial to the students. But it seems to me that the Oregon and Tennessee statutes don't necessarily carve out new rights or give advantage to those students in Tennessee or Oregon based on a comparison between the policies of Tennessee and Oregon and what current NCAA policies are, as I understand it. I just want to make sure that's accurate, that there isn't a proactive need to provide and protect rights for Wyoming student athletes based on what you've seen. Is there? That would be something for us to contemplate.
Ms. Swangan?
Mr. Chairman, Mr. Co-Chairman, I think these laws that I looked at are more just defining that right
Okay.
and then putting some sideboards around that right.
Okay, great. Thank you.
Ms. Swangan, please proceed.
Mr. Chairman, I actually don't have any more to this memo. It's a pretty brief overview, but like I said, I would be happy to look into more states if the committee would like more information on any particular state or any particular policy.
Mr. Co-Chairman?
Mr. Chairman, I think we're fine right now. I mean, the ones that I feel like are most specifically relevant to the discussion we were having are these California, New York, and Florida. And honestly, seeing, I don't know if you had a chance to look at the laws that Ms. Wangan included. One of the things that stands out is they're pretty concise, actually. They do a little, they're a little bit different from one another. They're not identical. They capture similar spirits, but they're not unwieldy statutes, and it might be a good starting point for us to look for identifying some protection of rights for Wyoming citizens as we move forward into a name, image, likeness, and data capture era, where your image and name can be potentially exploited for somebody else's commercial benefit. These seem like good templates to start that discussion and maybe provide some protection for Wyoming citizens from being commercially exploited without their permission. So I'm happy to see that. As we talked about the consumer data privacy, which we'll get into a little bit later, those bills are 38 pages to 120, I think, pages for the California Consumer Privacy Act. These are nice 2-pagers, and it's
the old keep it simple.
that's
Yeah.
right. There's some
Yeah.
there's some nice simplicity to these that I
Mr.
find
Co-Chairman,
attractive.
are you inferring that the legislators might overthink things? when they talk about
Occasionally,
that? Oh.
occasionally, I like the straightforward ones that are a little easier to get the point across.
Sure.
But yeah, thank you. And Ms. Wangan, again, thank you. Really appreciate seeing you here and having you do this work.
Any questions online for Ms. Wangan? Seeing none. Thank you very much for this. Appreciate that.
We might have public testimony on this, I guess, huh?
Yeah, I was about to say, we'll take public testimony, one by one. Was there
Yeah.
any on this briefing, any of its contents online? Seeing none.
Okay, good.
Mr. Hopkinson, do you want to kind of follow up on the co-chairman's comments on, bring us up to speed on 25 LSO 0088?
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, taking a look at 25 LSO 88, working draft 0.3, data privacy government entities. So I will just go through and highlight what's different in this version than from what the committee looked at in May. And the first thing is on page 3 in paragraph 5, the definition of personal data. And what we see, the change here is actually just a deletion. The previous version had an exception for publicly available information. And that is deleted in this version of the bill.
Mr. Co-chairman.
I think it's worth kind of discussing why that would be the case. In the previous bill draft, there was language around personal data does not include publicly available information, et cetera, et cetera. This legislation is specifically targeted at what the government can and can't do. Publicly available information either is something that you might have a public record access to, in which case you already have a preemptive public record right to get information, and that may or may not be publicly identifiable, including personal data, but that statute is going to govern in that instance based on the way this is constructed. For circumstances of generally available public data, the kinds of things that you could find on the internet, et cetera, the consideration here is while it's on the internet, it's not going to be subject to this act effectively unless some agency takes it from the internet, turns it into an identified public record, which is then personal data, then they would be responsible for it. So even though it was at one point generally public data, the act of the Wyoming government, some entity taking it and turning it into one of their records, well, yeah, the public would want to know if you scraped their Facebook page recorded all of the data and made it a public record, that should be subject to scrutiny and oversight. So that was the discussion that kind of went on for why, upon further reflection, the personal data definition doesn't need to have those exceptions, and it just then comes down to information that is linked or reasonably linkable to an identified or identifiable natural person or personal digital identity, and does not include de-identified data. So that was the analysis behind that deletion, and I think it's just kind of important to go through that thought exercise of why that line was removed. And with that, if there's no questions, Mr. Chairman, Mr. Hopkinson
Yeah.
can continue.
Mr. Coachman, I think that's a valuable point, and, you know, one thing that might be worth considering, perhaps it's beyond the scope of this particular legislation, is I do think at some point it's worthwhile to have the conversation about really digging into what is de-identified mean, because the more I learn about it, the more I realize that depending on the type of data, it's actually pretty easy to de-identify it, right? And obviously that's a whole different consideration, but I know
You mean re-identify?
right, exactly.
You mean re-identify?
Yeah,
Yeah.
and I'm coming
Absolutely.
quickly coloring outside the lines on this one, but just food for thought.
Yeah.
Mr. Hopkinson, please proceed.
The next change that we'll see in the bill draft is on the next page, page 4. Subsection A has been broken out into different paragraphs. And paragraph 2 is new. And that provides that a government entity may petition the governor for an exception to the subsection on a case-by-case basis. And the governor in his discretion may publicly approve in writing an exception to this subsection not to exceed a term of 2 years per petition. And so what that's providing the exception to is just to subsection A, which is that prohibition against a government entity purchasing, selling, trading, or transferring personal data without express written consent. And then paragraph 3 is also new.
And
Mr. Co-Chair.
Mr. Chairman, providing a little background on that for the committee will remember at our last meeting, some of the discussion with the Department of Health on some concerns they had related to the way they access some information for Medicaid ends up being using third parties that they purchase that data from under some circumstances. And so without getting deep into the weeds on that, we actually had language similar to this in the original bill draft, I guess, from last year. We amended that out because we wanted a justification for having that language. And then what it seems like is that the Department of Health came in and gave us a justification for that language. So this provides a vehicle then for example, the Department of Health to say, all right, this is critical data for us. This is the only way we can get that data. Governor, we need you to sign an exception waiver. And then you've got what is effectively a public document here. So it says may publicly approve in writing an exception. So that means that that's going to have to be publicly available on file, that the state of Wyoming is purchasing this information for this purpose. And the 2-year term in the discussion was not a limit. That's it. Just you'll have to sign a new waiver 2 years later. Every 2 years, basically, you'll have to continue that policy. So it's not one of those policies that gets signed off in 1983 and then is forgotten as an executive order that continues, and that data collection continues forever. So it makes sure that whatever the justification was for that exception still has to rise to a justifiable exception request every couple of years. So that's the impetus for paragraph 2 there, to try and remedy that Department of Health concern in a reasonable way.
Thank you, Mr. Co-Chairman. Committee members, any questions? Please continue.
Paragraph 3 at the bottom of page 4 is also new. Provides that nothing in the subsection shall be construed to prohibit the transfer of data that is otherwise compliant with the Health Insurance Portability and Accountability Act or the Family Education Rights and Privacy Act. So it does provide a bit of a carve out there for HIPAA and FERPA. One thing that I did miss in making changes on page 5, line 18, it just provides for 30 days for the response. And I think there had been discussion that should be changed to 60. So I can make that change. But that a government entity would have 60 days to respond to requests for information. And then finally, the last change is on page 7 in subsection C. And there's just a new sentence at the end of that subsection. This is where, or this subsection is dealing with the government entity. That no government entity shall maintain personal data for longer than 3 years without an express written policy identifying the extended retention period and providing reasonable justification for the extended retention period. And then new language, statutory retention requirements provided for in Wyoming statute 92405 through 92413. And that is the state archive statute, constitute a reasonable justification. So it's just providing some clarity there that those statutory deadlines do constitute a reasonable justification for extending that time period. Mr. Chairman.
Mr. Co-Chairman.
Thanks, Mr. Chairman. And the committee will recall the discussion with our state archives at the last meeting where there were concerns that this would conflict with state archives retention requirements, particularly the 3 years, where the default is actually 10 years for a lot of records under the retention requirements. And then there are different provisions under the retention requirements for certain amounts of time. I had the opportunity to meet with the state archives and talk through how this could work and what their concerns were. One of the concerns was, even though this language, upon reflection, probably doesn't conflict, there's the potential for it misleading. And so the idea of adding the sentence is to make sure that somebody, for example, in a small city that's reading through this and sees 3 years, would potentially assume that, all right, well, if I keep a record for 3 years, everything's great, because it says here in statute that I need to keep it by default for 3 years. And so they set up a policy where they eliminate things in 3 years. Archives were concerned that that might be an interpretation, even though false, potentially reasonable for somebody that wasn't deeply versed in the law. So the request was to make a clear reference back to those statutory retention provisions that are in place that are already governing, so that nobody will read this paragraph in isolation without knowing that there are retention paragraphs. And so, Mr. Chairman, it really doesn't change anything by intent or as I read it, but that's the justification for adding the paragraph to assuage those concerns of our state archives in having a perceived conflict with the retention records that are out there. And one of the interesting things was really learning more about our retention records policies in statute. You know, we're not delving into those in this bill, but some of those might be thoughtfully too long or whatever else. And it might be something for us to dive into more deeply later and think through, do we need to retain all of the records as long as we statutorily require retention? There are some unintended consequences there that might come up. And there's also some issues of redaction that might come into play, but again, that's probably outside the scope of where this bill is at this point. So it might be getting too far into the weeds for what we would want to accomplish in 1 year, and then maybe focus on that down the road if it's something that we hear more about and it continues to interest us. So that's the justification for lines 20 through 22 on page 7.
Thank you, Mr. Co-Chairman. Any other questions? Mr. Hopkinson, please continue.
Mr. Chairman, those were the differences between this version and the last one. So with that, I'd stand for any questions.
Seeing none online or in person. Let's go ahead and do state agencies. I know we've got some folks that have been very patient. So please,
I don't know if they have anything, but you're welcome.
okay,
Here to
Yeah.
answer questions.
here to answer questions. Okay, well, plenty of those. Any other agencies in the room? Anybody in the public? Sheriff?
And did we have anyone online from state agencies? Good,
Okay.
thank you.
Okay. Mr. Thompson, obviously I know who you are, but for the record, please state your name and who you're with.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. And I was just looking through the bill. I see the changes from the bill that was in the last session to now, and I think those help clarify the law enforcement standpoint from it. But as I look through the definition of law enforcement on page 3, which takes up pretty much the whole middle of that page there, it's a pretty extensive definition. And if you look at line 12 on page 3, that full sentence, well, portion of the sentence says that the focus of that agency is the prevention or investigation of crime and the enforcement of penal, traffic, regulatory, or criminal laws. If I could make a suggestion that in order to encapsulate all law enforcement, changing that "and" in the middle of there to an "or," that "and" is on line 12. Because I know that, like, for example, Highway Patrol was defined specifically above, DCI specifically above. But we do have agencies that are very specific in their scope. And so those that are in the prevention or investigation of crime are not always in the enforcement of penal, traffic, regulatory, or criminal laws. I don't have much experience with some of our entities like the Wyoming Livestock Board or the Outfitters, law enforcement arms, but we do have law enforcement personnel in those fields that are very specific in their scope. So I just would ask the committee to consider changing that "and" to an "or" to fully encapsulate all those law enforcement that might be affected.
So just really for my edification, let's just read that with the suggestions in
Sure.
place. Law enforcement agency means a county, municipal, college, or university police force, Wyoming Highway Patrol, Division of Criminal Investigation, Department of Corrections, or any state or local agency or political subdivision or part of an agency or political subdivision to the extent that the primary purpose of the agency or political subdivision or part thereof is the prevention or the investigation of crime or the enforcement of penal, traffic, regulatory, or criminal laws. Mr. Chairman, that's a mouthful. I mean, it certainly makes sense to me. I'm tracking your intent and its impact. And Mr. Co-Chairman, do you want to?
Mr. Chairman, at first blush, I think that's just fine and is the intent. I'm trying to think if there's any reason why it wouldn't be, and I'm not coming up with one. One thing, Mr. Chairman, that you'll recall as this legislation was being drafted, there was an expectation that there would be a definition somewhere in statute of law enforcement agency that would appropriately cover all of the law enforcement agencies. And there was not. Right?
Turns out.
Which was amazing. So here we are awkwardly creating a definition of law enforcement agency in a bill related to data privacy that is the most, in theory, accurate and comprehensive definition in all of Wyoming statute. So we might as well get it right, and then other people can reference it later if they choose to.
I like it.
Yeah, I think the "or" is probably okay. Mr. Hopkinson, is there anything that you see? I feel like "or" is actually the spirit of it, probably.
And just looking at that, Mr. Chairman, I don't think that gives me any heartburn.
Yeah.
Changing it to "or."
Thank you, Mr. Chairman. I don't know if anyone else on the committee has any.
Let's make sure.
I don't know, maybe Senator Nethercott, she's spent a lot of time on Judiciary Committee. She's a pro in this game. I don't know if she has any thoughts on it.
Yeah, Senator Nethercott, are you with us as our
I think it'll be,
law enforcement expert?
Good, okay.
Mr. Thompson, did you have any other additional comments on the draft?
No, thank you, Mr. Chairman. I'd be happy to answer any other questions you might have.
Okay. Seeing none. Thank you very much. Appreciate it. Anybody else in the room for public comment? Okay. Anybody else online? We've got one, Clarissa? Oh, okay, excellent. Let's go ahead and, Ms. Barco, we know who you are, but just for the record, state your name and who you're with, please.
Mr. Chairman, my name is Ruthie Barco and I represent TechNet. Shall I proceed, Mr. Chairman? Sorry.
Sorry, Ms. Barco, please, yes, proceed.
Thank you. TechNet is a national bipartisan network of technology CEOs and senior executives. We promote the innovation economy. We are providing the initial feedback that we could on a short turnaround, but I preface my comments by saying that we will be providing additional detail on this bill as needed. We voiced some of these concerns during the 2023 interim when the previous draft bill on this topic was considered by the Select Committee. And we find this bill to move a little bit further away from what we voiced previously. So we will be following up with additional documentation. The previous bill prohibited the purchase of personal data, which was already problematic. And then this bill creates further concerns by now eliminating the exemption that it did have for publicly available information. We were asking for other changes to that definition that was in the previous bill. And now, we would actually just like to see some of that reinstated. The impact of this bill would hence be twofold. It would prohibit the purchase of data by government agencies in the normal course of contractual business to provide the government services that they are mandated to do, and essentially barring access to public records, which of course raises First Amendment concerns because the government cannot block access to data. We see issues with the limitation this bill places on the purchase of data by government entities because government entities are often reliant on third parties' data sources to provide government services for Wyoming citizens. Members of the Select Committee heard testimony on that from state agencies in the last meeting, notably from the Wyoming Department of Health and the Wyoming Archives Office. This bill could result in government entities being unable to use critical sources of data, which in turn would affect the provision of government services, as agency officials elaborated on in their presentations. Some examples include determining benefit eligibility for public programs like Medicaid, updating contact information to reach citizens who qualify for government programs, but maybe disenrolled during redetermination because the government is unable to reach them and their contact information has changed. Verifying the identity of individuals applying for public benefit programs to prevent fraud or tracking individuals who are delinquent and paying child support. We suggest that in order to remedy these issues, removing the prohibition on purchasing. In recent years, 20 states have advanced comprehensive state privacy laws. Largely, they track a standard of clear, actionable consumer rights and explicit controller responsibilities. We ask that the Select Committee conduct a thorough review with legislative staff to review these other bills and how they match up with the draft language in 25 LSO 88. In recognition of these existing laws and in anticipation of potential further future action by the Wyoming legislature on this topic, this bill should, where applicable, ensure that it is utilizing legally defined terms already enacted in other states to create alignment between state privacy laws. As now almost half of the states are moving towards enacting laws that deal on this topic, although those are comprehensive and this is dealing with a limited case, regardless of whether the laws apply to public or private entities. States with comprehensive consumer data privacy laws have largely adopted an exemption of publicly available information because of the First Amendment issues we raised earlier. We ask that at minimum, this bill draft reinstates the 2024 bill draft language that ensured an exemption for, or excuse me, 2023, that ensured an exemption for all records made lawfully available by federal, state, and local governments. Thank you for the consideration of our feedback on this bill, and we look forward to being a resource to the Select Committee.
Thank you, Ms. Barco. Members, any questions? I've got a couple, but Mr. Co-Chairman, it sounds like you were, or is there another comment?
Mr. Chairman, thank you. I just want to express my concern that anytime we're discussing information, therefore the First Amendment applies. That is not accurate. The First Amendment protects speech, not information per se. And so the allegation that any publicly available information has First Amendment protections, I think, is a misstatement of the law and dangerous, potentially. Two, I also heard a statement that the government cannot restrict access to public information. Well, the government actually defines what is public information, and we do, in fact, restrict that. There are lengthy exceptions to any kind of publicly available information, and what is deemed publicly available, recognizing that the government does in fact possess a great deal of information about its citizens and has a great deal of responsibility to keep that information confidential due to the Fourth Amendment right to privacy. So a lot of constitutional provisions we can trigger in this conversation, But I think it's important to recognize that a great deal of caution needs to be made when it comes to these constitutional amendments being thrown around as a basis for rationale for this particular law. And just another comment, I do have concerns as well about how the government then can use this publicly available information for child support enforcement and other efforts. And so these data companies can sell your information to the government. So those of us who are concerned about the overreach of government or limiting government or too much power of a government, certainly some concerning policy considerations for us all to weigh.
Mr. Chairman,
Thank you, Ms. Endicott. Any questions for my co-chair?
just
Mr. Co-chairman, please.
Well, honestly, just following on Senator Nethercott's point there, that is one of the concerns that that inspired this legislation, is the idea that the state of Wyoming would effectively purchase third-party data about residents of the state of Wyoming. And then oddly enough, that third-party data that would have been purchased would then probably be a public record that is no longer protected and owned by the state and subject to retention schedules. So one day we didn't have a bunch of confidential information on the public that's in theory being protected, their privacy is being protected from government intrusion, as Senator Nethercott noted. And then all of a sudden we have a huge database of personal data related to them that could be queried by another third party and then resold about those individuals. It could be aggregated and resold. That's exactly at the heart of what this bill is trying to protect against. And I do realize that there's a commercial interest in buying and selling personal data about individuals, and this happens all the time, and there's a lot of money being made. The spirit of this bill is to try and keep the Wyoming government out of that business. So I think it's just a difference in interests between some in industry that are looking for financial gains and those of us that are representing the people of the state of Wyoming, where it's our obligation to protect their privacy rights and their individual rights as our highest goal and priority. So, Mr. Chairman, I appreciate Senator Nethercott's strong thoughts on that topic. And Mr. Chairman, one other thing I just would note is page 6, the D paragraph. To the extent that a provision of the article conflicts with another provision of state or federal law, the other provision shall control. That is specifically there with our Public Records Act in mind. So nothing in this act in any way limits the existing Public Records Act and access to public records. And Mr. Chairman, the other point about addressing agency needs where there are specific purchases that have to take place and there's no workarounds, that's the purpose of the 2 paragraph on page 4, as I mentioned earlier, which would allow the which would allow the governor to provide an exception where one is justified, but it has to be a case-by-case basis with public approval in writing for that exception. So that allows our public then, if data is being sold about the public or purchased about the public will know, because there'll be a public document, and the governor of the state of Wyoming would have to go on record supporting that. So the intent there, Mr. Co-Chairman, is to ensure that there's some good thought behind it before the governor is going to say, yes, this is a good idea, we're willing to buy this data set. I think that addresses all of the concerns that were raised, and I appreciate the thoughtfulness that went into this draft trying to address those prior concerns raised. So that's all I have for now, Mr. Chairman.
Yeah, thank you, Mr. Chairman. I emphasize that controlling provision about what's already existing elsewhere in statutes. Are there any further questions for Ms. Barco? Seeing none, thank you very much for your testimony. We've got,
Brendan.
of course, an old friend of this committee, Mr. Maher, please.
Yes, thank you very much. Thank you, co-chairs and committee. My name is Brendan Maher. I'm an MIT Media Laboratory alumnus. And I was involved in the Wyoming Digital Identity Act. And I have a small comment regarding a reference. And I wanted to bring attention to the committee, the item, which is our statute reference 9-21-101, Romanet number 6, where we define personal digital identity means as defined in WS 8-1-102, what is that, 18? My comment is, yeah, that's a great reference. However, it does not reference the full Digital Identity Act, which is 40-30-102, A number 1. And I actually do feel that it is important to reference the Digital Identity Act as well, because that has a fuller definition, which is inclusive of the 8-1-102. And this will become important as we begin to further refine digital identity. And I'll speak more of this, I hope, to give a small testimony in the closing remarks, although it will be regarding organizational digital identity and doing business as digital names. It will eventually transcend out into other forms of digital identity, as in personal digital identity. I hope this is helpful in terms of adding the Digital Identity Act as a reference, and I'll take any questions.
Thank you, Mr. Maher. I think that might be worthwhile to try to include the full act. But was there any questions for Mr. Maher from the committee online?
Mr. Chairman.
Mr. Co-Chairman.
Thanks, Mr. Chairman. I think with the way this is constructed, we want to retain the mirrored definition. The intent here was to put a definition of personal digital identity and to link it to that part of statute so that we don't have to define it. The act still applies and governs. So it's not as if we're being exclusive to the rest of 8-1 when we don't have it in place. And I guess I would look to Mr. Hopkinson. I think this construct is still the right construct for what we want to accomplish, even though the rest of the digital identity statute is an essential part of it. See,
Mr. Hopkinson,
David agrees.
would you agree?
Thank you, Mr. Chairman, and yes, and I would note, the Digital Identity Act also does reference back to 8-1, 802A18 in that definition. And that is the Title 8-1-102 is what's broadly applicable if there's no other specific definition. So we could just strike that definition entirely, but in previous versions, the committee wanted to include it in there just so people would have an idea of where to look for what that definition means. And so given our typical statutory construction, things of that nature, I do think the appropriate place is to reference 8-1-102, and it doesn't diminish or restrict or otherwise alter the effect of the Digital Identity Act.
Mr. Co-Chairman?
Yeah, Mr. Chairman, I appreciate that further description. I think it is in good shape. And remember, as Mr. Hopkinson just pointed out, those 8-1-102 definitions are definitions that apply generally throughout statute unless there is a superseding local definition. And so as Mr. Hopkinson pointed out, if we were to delete Romanet 6, it would be functionally equivalent under statute because it would go back to that definition. And the only reason for that Romanet 6 being there is the callback, so to speak, to ensure
The reference.
that somebody recognizes that it's an 8-1-102. So I think it's structured appropriately from that concept.
Mr. Maher, did you want to weigh in on that or?
Yes, I will say it is a direct copy. The lines are identical in both statutes. So certainly, if those are all of your opinions, I stand by that.
Any further questions for Mr. Meyer? Online, any of our members? Seeing none, thank you very much, Brendan, for your comments. We appreciate them. Let's see.
I think that's probably it.
That's pretty much it. Yeah, one last call for in the room. Not seeing any. Push anybody else online? Excellent. Well, we will go ahead and close public testimony on 25 LSO 0088. Committee, what's your pleasure? Mr. Co-Chairman?
Yeah, Mr. Chairman, I think we're ready to move this one on, but I'd want to look to other members of the committee, both here and out in Zoom land, to see if anyone has any reservations to taking action on it right now. If there's anything more we need, I feel like we're in a good spot, but
Yeah, I think
we've got another meeting. So if anybody feels like we need more work, we can do it.
Mr. Co-Chairman, that's fair. Maybe I just kind of take the temperature of folks. I mean, is there any hesitation amongst?
You guys good?
Yeah, I don't think so. Representative Yin or Senator Nethercott, Senator Furphy? Any major heartburn at this point?
Mr. Chairman,
Senator
although,
Nethercott.
yeah, although I'm ready to, take some action, I do think it might be prudent just due to the low participation of this meeting on this week, even both online and in person, that maybe we put it on our next agenda.
Yeah, that's fair.
Senator Nethercott, I thought this was the meeting to be at in the state of Wyoming. I take a little umbrage, but I suppose we can
Everybody's here.
we can afford that that encouragement or that request. Excuse me.
That's sound advice. Let's
Sure, we can. I think we've disposed of enough. We probably have enough room on our September agenda.
hopefully it won't take long.
Hopefully it won't take long. Representative Singh, anything to add?
Thank you, Mr. Chairman. If this is the appropriate time, I do have some information on a bill that was passed in
Let's
Colorado. We can carry that over, or I can present it now.
dispose of this question, but
Sure.
Yeah.
that will be right up next. So absent any sort of objection, let's forward further consideration of this issue onto our September meeting in Laramie.
Sounds good.
All right, Representative Singh, you're up.
Thank you, Mr. Chairman. Do you want me to just stay right here? That's fine.
Yeah, you can present from there.
Alrighty, well, thank you for the opportunity to share this with the committee. Mr. Chairman, this is House Bill 24-105 from the state of Colorado. It is, what it does is it expands the definition of privacy, what is under the scope of privacy within the state of Colorado to include biological information and neural information that can be recorded and then transferred and traded with entities online for profit. And so I thought a lot about this bill. I thought it was a neat piece of legislation. It's a bipartisan piece of legislation from the state of Colorado. It was able to pass this year. It was signed into law by the governor down there. And what really makes me think about this bill is from Article 1, Section 4 of our Constitution, which says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant issue shall be but upon probable cause, supported by an affidavit, particularly describing the place to be searched and the person or thing being seized. And so I think this bill poses an excellent question as to whether or not we want to include biological information, which is certainly sensitive information that we wouldn't want to be necessarily circulated or retained by the government or any entity at that could potentially be sold for profit.
So Representative Ying, or Representative Singh, my apologies. You know, most of this bill, the first 3 pages or so is findings, but is there any specific passages that really that stick out to you the most in the remainder of the bill?
Sure. Thank you, Mr. Chairman. So if we go to page 5 on section 2, it actually will be the definitions of biological data and neural data. So this is in the Colorado statute 6-1-1303, and that is the Colorado Privacy Act. And so already the state of Colorado had established that through the advancements of technology, new types of sensitive information will exist. And they explicitly laid out digital information, amongst other things that would be protected under their Privacy Act. And so this year they added the terms biological data, which means data generated by technological processing, measurement, or analysis of an individual's biological, genetic, biochemical, physiological, or neural properties, compositions, or activities, or of an individual's body or bodily functions, which data is used or intended to be used singly or in combination with other personal data for identification purposes. And it also included neural data, which means information that is generated by the measurement of the activity of an individual's central or peripheral nervous systems that can be processed by or with the assistance of a device. This sounds, I understand that this may sound silly to bring what sounds like futuristic technology, considering futuristic technology in our green books, in our statutes. But in this particular case, when it comes to the people's privacy, the conversation as to whether or not to be on the cutting edge of what technology exists and the type of information that can be extracted out there in private and in public settings, that's something that I feel this specific committee should be thinking about. If we have situations where people are able to fly drones and get footage of individuals while they're in public, that's one thing. But if you were to equip that drone with the technology to scan someone and produce a 3D image of them at will, how much privacy does an individual have when it comes to different ways of measuring the world around us? And so thank you for the chance to talk about that.
Yeah, Representative Singh, I think maybe 5 years ago, 10 years ago, this might have been, loony, but I think, you can go on YouTube and check out the demonstration of Neuralink, right? So it's very real. And so I think it's, these kind of definitions are worth considering. Mr. Co-Chairman, did you want to weigh in or?
Yeah.
Or go ahead, please.
Mr. Chairman, I appreciate Representative Singh bringing this to the committee. It's an interesting discussion for us to take into consideration. I think one challenge for us is the context that Colorado has versus what we have and have been working on. Colorado has their Colorado Privacy Act, which is within their Colorado Consumer Protection Act. And so they have the capacity to amend in this additional protection. We have looked at through this committee similar protections in Wyoming and have had those drafted, but don't have anything in statute at this point that provides it. And part of the concern there is how consumer oriented this is and the challenges with the fact that a lot of these bills, and it really started with GDPR and in Europe and then in California, come at citizens from the perspective that they are first and foremost a consumer, and then provides consumer protections for them, as opposed to a rights basis where they're not simply consumers, they're citizens with rights. And that's always been a bit of a challenge. At the same time, these statutes do provide a stronger protection for the citizens of those states than what we have available. So we probably need to find a way to get to this objective for Wyoming citizens, whether we call them consumers or whether we call them people of the state of Wyoming. I think as we move forward with that discussion though, and hopefully we can have that as a topic for the next meeting, which will take a bit of time if we can put something together, incorporating this protection does seem essential. Now we also have a very strong Genetic Information Privacy Act that has some similar or parallel protections, I guess I'll say. That could be an area where we could look at trying to modify and at least give some consideration to whether we could amend a similar definition into that. And I don't know whether it's a good idea or not. I just know that we put together a good bill on genetic information privacy and have some pretty robust statutes there.
Representative Ying.
That's, yeah, I'm gonna write that.
You know, it's late in the afternoon,
It's late.
okay? Mr. Co-Chairman, little grace.
It's all right.
Representative Singh.
Thank you, Mr. Chairman. I would even consider extending the definition to behavioral patterns that could be traced online. That would be outside the purview of public access from being traceable to the public, right? That would be a type of privacy that should also be protected and not be exposed to the public.
Representative Singh, so is the ultimate aim, do you want to incorporate these definitions that we talked about in this draft into what we're working on now, or are you looking for a new bill draft, or what kind of direction are you thinking?
Well, if it's applicable, thank you, Mr. Chairman, if it's applicable to incorporate the definitions that we have in this bill to the bill that we're working on, then I would certainly be open to that. However, if there is already existing statute in which we'd be able to plug this in, then I would also be open to that.
So, Mr. Co-Chairman, this is, appreciate that clarification from Representative Singh. Mr. Co-Chairman, my thought is that we did forward this on to the next meeting for further deliberation. We can put that as a topic and how, if it's a fit into there, or if it's kind of a bit of putting a square peg in a round hole, we can maybe figure out alternative options there as well. Mr. Co-Chairman, what are you thinking?
Well, one other area that we do have statutes, so we've got the Genetic Information Privacy Act. We also have, probably from 8 years ago-ish, we updated the personally identifiable information statutes for information that's protected for citizens of the state of Wyoming. And some of that is from the commercial side, where there are some disclosure laws associated with if there is disclosure of your PII. We adjusted that definition, as I said, about 8 years ago, to be a little bit more expansive. We could look at that statute also and see if changing that definition to add something similar to what we see in the Colorado law. That's a pretty straightforward and easy bill, because we're just changing a definition, and then PII is protected in certain ways in the remaining statute. So it would probably be an insertion in a definition. And if it is that simple, and if there'd be value there, that might be a good bill for us to do next time. Those are not necessarily robust protections, but that is what our agencies look to for handling of sensitive data. For example, if it contains personally identifiable information, then we have provisions that require additional protections. And as I said, if on the private sector side, if there is a disclosure of PII, then there are some provisions on what you have to do if that's disclosed. So it could be a simple addition there that might provide the beginning of some protections, but then trying to incorporate it into our more robust protections as we work on a Wyoming Privacy Act or something along those lines would be a good idea.
Mr. Co-Chairman, real quick, I just want to check in with LSO and Mr. Hopkinson. I mean, how arduous would that be to maybe do a small briefing on that topic for September? How big of an undertaking are we talking there?
Mr. Chairman, I could certainly discuss that with Chairman Rothfuss, and if it seems like something we can provide, I don't have any problem with that.
Yeah. Mr. Co-Chairman, absent objection, maybe just kind of see how closely what Representative Singh is talking about tracks with what we've already got in our PII statutes and our genetic testing language that we've already got on the books, if that's,
Yeah, and
Mr. Co-Chairman.
Mr. Chairman, the more I consider the Genetic Information Privacy Act, I'm not sure it would fit in there without really having to lever it in. So that might be work. But thinking back to the PII statute that we amended, I really do think it would be somewhere on the order of a 3 or 4 word insertion in statute and still have some legal meaning. So maybe that's something that we could investigate. And if it is that simple, we could potentially provide a very short bill draft for our consideration to
Sure.
amend that in. I think that's reasonable. So, Mr. Chairman, if Representative Singh is so inclined and there's no objection, maybe we can just have, a soft suggestion that we'll pursue that and try and develop a bill. But if it looks more complicated, then maybe we fail out and it takes a little more time.
Yeah. Representative Singh, that's kind of my thought. If it's something that's not too arduous for LSO, maybe we can come up with a draft. But if it looks like it's going to be some pretty heavy lifting and research, maybe we just punt that one until to the 25 interim. Is that, Representative Singh, does that sound amenable?
Thank you, Mr. Chairman. I think that's a great plan. I'm just grateful for the chance to present the idea. And I also think it's important that we get the input from folks in the healthcare profession on how this would
Mhm.
impact their field.
Certainly.
Motion has.
Representative Andrew, please go ahead.
Thank you, Mr. Chairman. This is a really interesting topic, and the part that I find probably the most concerning and where I've kind of been looking into this topic as well is the fact that we do have the availability of, well, not availability, but the possibility and, lab-based actual results of devices that do have the ability to basically interpret brainwaves to tell what someone is thinking, which just sounds so crazy to me, but it is real in at least some controlled lab sort of situation. And how long until that maybe is a little bit more accessible to people? I mean, a lot of this stuff results from things that you put out there, like you actually, in order to have web data, things like that, you actually have to perform actions. Whereas with this other topic, you sort of run into a situation where you could destroy somebody's privacy of mind, which is a whole much larger step further. And I don't know exactly what you could do about that to get ahead of it. I don't know if you need to create some personal right to privacy of mind that's actually, I would think, is probably implied in law, but was certainly never contemplated, and perhaps something could be done in that realm.
Representative Andrew, thank you very much. Again, I would just suggest you to look at the most recent Neuralink demos. I think that kind of gives you context where we're at. Mr. Co-Chairman?
Yeah, we do have a little bit of time, fortunately, because Neuralink and technology that actually works in understanding what you're thinking with any depth is subcranial. So you'll fortunately probably be able to avoid that level of intrusion without intent. But I do think it's important for us to be contemplative of that future risk, because there's obviously a tremendous amount of research trying to get past the subcranial barrier, where right now there's a dramatic difference in the information that's available subcranial versus supracranial, but we don't know where that technology is going to go, and having some protections that are proactive is probably always thoughtful.
Thank you, Mr. Co-Chairman. Real quick, was there anybody online that wanted to chime in before I go back to Representative Singh? Please go ahead.
Oh, thank you, Mr. Chairman. I just wanted to say that would be, we could lump that in under the description of emerging technologies.
I think we probably could. So let's go ahead to public comment on this one. Is there anybody in the room? Seeing none.
Brendan's in.
Okay. Was there anybody, is it just Brendan?
Awesome.
Ms. Bart, so let's, Brendan, we'll let you come in and give the last word if that's okay. We'll let Ms. Barco
Sure.
go before.
That's good.
you.
Great.
Okay. Ms. Barco, please.
Thank you, Mr. Chairman. Appreciate the discussion from the select committee. Again, sorry for the record, Ruthie Barco from TechNet. We worked quite a bit on the neural data privacy bill in Colorado, but that was actually not the only bill in Colorado that worked with the definitions of biological data. I would also direct the committee's attention to House Bill 241130 and to note for the committee's discussion on passing data privacy bills that you have the Colorado Privacy Act and the passage of House Bill 241130 in Colorado resulted in a tremendous amount of effort from stakeholders on multiple sides of this issue and legislators to try to figure out how to house that bill and align it with the existing Colorado Privacy Act. It was a biological data privacy bill. So we appreciate the caution that the committee is approaching this with, and we would urge that caution and encourage a great deal of deliberation on this topic before moving forward. We appreciated the co-chairman's comments about where this would actually be housed and how could this actually be done without having a comprehensive data privacy bill to pass first. So as I noted in my previous testimony, 20 states at this point, I believe, have comprehensive data privacy bills. You see that, it allows for additional layers of legislative work to be done over them. And specifically to the neural data privacy bill, and also kind of underlining the process on the biological data bill in Colorado, we were very focused not so much on the addition of this new category, but on making sure that this new legal term, which is completely untested, and Colorado was the first state to pass it, was actually appropriately targeted. So what Representative Singh read for the committee could actually be interpreted broadly, if someone wanted to enforce it that way, to apply to anything that measured a bodily movement was our concern. There's obviously a number of consumer-facing devices that, could fall under that definition, because if you're talking about the activity of the peripheral nervous system that is measured by a device, we thought that some other words such as the neuronal activity of the peripheral nervous system or direct measurement by a device could actually help target that more, so that it isn't just looping in a whole category of devices that were not intended to be included in the enforcement of this language. Additionally, why would we be categorizing things in a law that are neural data when they actually have nothing to do with brain activity, was our argument. So just like with the discussion on AI yesterday, these are emerging technologies. They require a great deal of deliberation. And that's why we were very engaged on that bill in Colorado and where this issue continues to come up. So I will take any questions from the committee. Please let me know if there's anything else we can provide.
Any questions for Ms. Barco?
Mr. Chairman.
Ms. Co-Chairman?
Thank you, Mr. Chairman. We've had a number of discussions on emerging technology, and it's been a theme about the government's being very careful in testimony, and that we need to be very thoughtful and careful about regulating these advanced technologies and emerging technologies. But I guess the question is, what is industry doing to be careful? Because what we see, and this was something he cautioned us against yesterday, is it's challenging for the government to thoughtfully reflect on the nuances of advanced and emerging technologies in a way where we have an appropriate regulatory structure that doesn't stifle innovation and that protects consumers, right? That's a balance that we always have on this select committee, and we aspire to that regulate to enable type concept. But from the perspective of the folks that you represent through TechNet, Ms. Barco, it seems that the approach is a no holds barred. We're going to do everything we want to do, and then we'll see what happens. And then maybe something needs to be regulated. It almost seems like there needs to be more responsibility among the innovators to proactively determine what the risks are and then identify those risks instead of just say, let's be careful to the regulating side. So what's being done by industry to help legislators such as us head off these risks rather than honestly just warning us to stay out of your business.
Ms. Barco.
Thank you, Mr. Co-Chairman. I think that question relies heavily on where individual legislators or any stakeholder views that fulcrum between the government's responsibility to both protect its citizens, but also provide services and support its own economy and its innovation. That's a detailed, subjective answer person to person. Our involvement on the neural data bill had nothing to do with actually the responsibility. It was more about let's make sure that when we are putting legally defined terms into state statute, that they are appropriately tailored. We just didn't think it made any sense to apply the definition of something that had to do with your brain waves to something that was neural activity to something that absolutely was not measuring your brain activity. So in some of the earlier iterations of that definition, you would have been classifying in Colorado law you pressing your brake pedal on your car as being neural activity. That's not neural activity. That's not your brain activity. But because because most cars have the ability to measure to the extent to which you are pushing your brake pedal, under these earlier iterations of that definition, that classified as neural activity. We were simply calling for accuracy. We weren't saying that this shouldn't be added as a category. We weren't saying that companies developing and researching this sort of technology shouldn't absolutely be scrutinized as to how that data is being used and protected. We were just saying that category of data should be accurate to what we are trying to enforce and regulate.
Okay.
Mr. Co-Chairman.
Okay, thanks.
Committee members, any further questions? Representative Singh, please go ahead.
Thank you, Mr. Chairman. And thank you, Ms. Barco, for informing us about your work in Colorado. What kind of, I do not bring this idea as an affront to the free market. I would like to be a friend to the free market, and I like to see, I anticipate that technologies that are able to collect this type of information will hit the free market and be available to the average to a consumer base eventually in Wyoming. And so how could we better word what exists in Colorado statute to not somehow stifle what people have access to?
Ms. Barco, please go ahead.
Thank you, Mr. Chairman. Thank you, Representative Singh. Absolutely. I think that with all of these technologies moving quickly, with there being so much adapted, and then obviously the law moves much slower, both in proactively addressing, responding, and then sometimes not being able to respond quickly enough if such laws need to be amended or the language needs to be tailored in time. So we're really just trying to act proactively to ensure that any language that is adopted avoids pitfalls. So if we're adopting language that is too broad, that it loops in technologies that actually are not neural, but we gave the argument multiple times that if some of the technologies today that are measuring bodily movements can also integrate technologies to measure neural data in the future, they should absolutely be included in this category. We just don't think that entire bundle of technology should be looped into that category hypothetically when they don't currently do that. We also think that if we craft appropriate and targeted legal definitions proactively, that those definitions will apply in the future when those technologies are in fact conducting that sort of activity monitoring and measuring. To your specific question about what we could do here, we simply thought that adding the word direct, so that was the direct measurement by a device, not just the measurement by a device, would be a really helpful and targeted improvement. And then when in relation to the peripheral nervous system, because the peripheral nervous system is anything outside the central nervous system that is basically a bodily movement, we've felt that if that was more targeted to say the neuronal activity of the peripheral nervous system and not just the activity of the peripheral nervous system, you would actually be targeting more of those devices that are trying to directly measure the activity of the nerves of the peripheral nervous system. So we thought that that was just more clear and accurate, frankly.
Representative Singh, follow up.
Thank you, Mr. Chairman. And Ms. Barco, you said that 3 times really, really fast, and that was impressive. Thank you.
Love wrapping up 2 days of meeting with a nice tongue twister. Representative Singh.
Good.
Committee members, any further questions for Ms. Barco? Seeing none, thank you very much for your testimony. And of course, last but not least, Mr. Maher, what you got?
Great. Can everybody hear me?
We can hear you just fine.
Yeah, great.
Please
Yeah, wonderful,
proceed.
wonderful. Yeah. Brendan Maher, an MIT Media Laboratory alumnus from 1996. And for this conversation, I was also one of the first people developing virtual reality in 1993. And also relevant to this conversation is on the Digital Identity Act. And we had spent 9 months looking at the Colorado law, which was derived from one of the Virginia laws and the California law. So there's a number of things I have to say here that I hope will provide some guidance for the committee in terms of how to think about these things and some path forward. And I should also add, of course, as we all know at this point, I'm a futurist and probably the resident crackpot in the room, having predicted much of the stuff that we're now dealing with artificial intelligence and general AI and many things. So I will say first off that I do believe Senator Rolfe's sentiment that these things are coming quickly, and Representative Western, they are not evenly distributed, but they are coming, and it is important to be looking at this now. To Ms. Barco's points and related to that, I think the thing that would be most constructive is twofold. One is that what we do is when we go forward with this, we look towards not what has been done with the consumer protection laws, because that's just a rat nest. Looking at where we can start from scratch would be very, very useful. The second point, actually, I'll take questions on that. Actually, I'll pause. Any questions at this point?
So, Mr. Maher, when we say start from scratch, is it because what we are dealing with is so fundamentally different in nature that it warrants having to kind of start from the ground up? Is that an accurate understanding?
Yeah. So, we and I read the Colorado Digital Identity Act probably at least 5 times. And many of us did on the Digital Identity Act, working through it. And starting from the basis of consumer protections, it's just impossible. It just doesn't work. Looking at these new technologies, I'm not saying it doesn't work, but it's as they wrote it, it's very, very difficult to make the statute in a way in which the future statute is adaptable to what is going to be changing with all these technologies in the rapid form that they're going to be changing. Right? We don't need static laws. We need laws that we can construct where we can easily swap in and swap out different pieces of them as technology changes, right? We've been talking about this for years. As Greenwood has spoken about it quite a number of, at quite a number of points in time. Looking at computational law, right? How to write law so that it is modular and it meets the flexibility to change with these changing technologies is very, very important. So I hope that is helpful, but I think the second point will be far more useful. But I'll pause.
Thank you, Mr. Maher. Any questions? Seeing none, please proceed.
Okay. I think this is probably the most important thing that I can offer the committee, and it goes towards the failings of where we've gotten to with all of the AI legislation globally. And hopefully at the end of this, we're all going to sit around and sing a song. Because the problem is that from a regulation standpoint, what we're trying to do is we're trying to regulate technologies and not applications, right? We're trying to do that. We're trying to do this with large language models. We're trying to say, like, this technology is something that needs to be regulated rather than the application. And if you stop to think about this, and I'm not the person who came up with this analogy, but if we applied this form of legislation to the motor, right, the electric motor, then we would be saying, well, anything that has an electric motor in it is something that needs to be regulated, right? So my refrigerator, my toothbrush, everything in between, my lawnmower, we'd be writing legislation for lawnmowers and toothbrushes and refrigerators, right? But what we really want to be doing is legislating how these technologies are used, their applications, right? The products or genres of products that they're in. We legislate the use of automobiles as they relate to autonomous driving, right? Not the use of a motor in a toothbrush, right? And so that's kind of the analogy here. So this way of thinking about legislation, I think, is extremely important. And I think it breaks the format of how other legislative bodies, not just Colorado, but globally, approach legislating technology. And I hope that's useful. And that's why I'm saying that, starting from scratch is useful. And I would say, though, to Ms. Barco's point, yeah, these things are difficult, and they do take a lot of stakeholders, and they're not simple. But I also think, related to Senator Rothfuss's point, that starting towards something with new beginnings is good. I do hope that's helpful.
Thank you, Mr. Maher. Any questions, committee members, for Mr. Maher? I certainly appreciate that, you got to draw the distinction between it. To use your example, are you regulating a electric motor in a toothpaste or in a 20,000-pound semi? So I think it's an important distinction to draw. Anybody online? Ms. Co-Chairman?
Mr. Chairman, I appreciate that conversation. I think Mr. Maher gets at exactly what the challenge we've been facing and struggled to overcome. And honestly, it's something the committee's been working on for quite a while, and we really haven't gotten past this idea that if we want to treat everybody as a consumer and come at the problem directly as a consumer, then there's good templates out there for what statute should look like, but those aren't future-proof and they're very narrow. So the struggle is, if we want to create something which is appropriately targeted based on those uses, as Mr. Maher described, and based on concepts of digital identity and digital citizenship and owning your own data, digital identity, self-sovereign principles, all of the types of things that we've been discussing for years, that becomes a heavy lift because it weaves together so many different concepts. And first of its kind, we need to get it right. But I still think that that's the appropriate approach to be forward-looking and protect not just people today, but our citizens moving forward. In addition, when we reflect on the conversation we had when we were working on our Wyoming Privacy Act and mirroring some of the other statutes in our draft, the applicability was very limited. For most of these acts, you had to be a multi-billion-dollar company before you were even subject to those acts. So there really wasn't a lot of true protection, except from, the major social media platforms, for example. And once again, contemplating loopholes, and this is always a challenge for us as legislators, trying to create legislation that doesn't have those huge loopholes. Oftentimes in the privacy space, there is an appearance of protection, but no actual protection because it's so easily circumvented. And in trying to achieve, high quality legislation, we've been reticent to pass legislation. So we are, Mr. Chairman, in a bit of a conundrum where perfect is the enemy of good on this to some degree, right? It would be good if we could get some protection in place. But the struggle has been getting to meaningful protection and doing it in a way that reflects Mr. Maher's appropriate concerns about trying to keep it future-proof. So, it's a long answer to this question and this discussion, but that's why we are where we are. And I think it's up to the committee maybe to give some thought to, do we want to try and put in place some measures that provide modest protections, maybe in the near future, and then try to improve upon those, maybe develop a framework in such a way that we can weave in better pieces in the future, but capture some of what's already been done. I think that's a reasonable approach that maybe we should consider for next meeting, is because we've got excellent drafts. Mr. Hopkinson put together some very good legislation. And the problems with the legislation were really more about the approach that was taken in other states than anything wrong with the legislation itself. So I think it's a good discussion for us to contemplate on how we want to handle that side of Wyoming citizen data privacy for the next committee meeting and bringing into the legislative session.
Thank you, Mr. Co-Chairman. Any other questions for Mr. Maher? Anything online? Not seeing any in person. Mr. Maher, as always, we do appreciate your thoughtful comments.
Glad to be of help, and
So-
I should say that's from Avi. That reference about the model is from luminary and legal lawyer Avi. I'm not pronouncing his last name right well, so I'll refrain from that. But he should get reference for that.
Thank you, Mr. Maher. Again, we appreciate your testimony. Any last call for public comment? We close public comment on this topic. So public comment is closed. Again, we've already kind of suggested, Mr. Hopkinson, just as you delve down this path, if it does seem like it's going to be a pretty heavy lift, please do let us know. But otherwise, see if there's something we can put together on this language in some sort of working draft for next meeting, absent the objection, which I'm not seeing any online. Representative Singh, is there anything else that you wanted to add on this before we move on to committee directives?
Thank you, Mr. Chairman and Mr. Co-Chairman, for your consideration.
Absolutely. Well, Mr. Co-Chairman, we're on to that part of the meeting where got to go over some committee directives. Mr. Hopkinson, could you maybe,
What are we doing?
keeping a general tab up here of committee directives, but could you maybe go over the litany of instructions that we've given? Thanks for coming.
Oh,
Are we-
yeah.
Were we? I thought that was general public comment. Was there any? Oh,
if you
yeah.
wanted to-
Yes, sorry,
did.
Mr. Maher, I apologize. Please do forgive me. If you've got the floor is yours to talk about darn near anything you want, so go for it.
It's good. It's DBA, the suggestion.
That's right. Go ahead. I think you're on mute right now.
Okay, can everybody hear me now?
Yep.
We
Yeah.
got you.
Okay, great. Yeah, great. Okay, very well. Wow, that was a very broad offer there to talk about it, whatever I'd like. I will try to keep it
Within reason.
Yeah, within. I will.
that.
You just may. I will be succinct as I can, and I will pause for breaks. But I will say, I guess I'm supposed to do the background. So Brendan Marr, MIT Media Laboratory alumnus, and I've been involved in the Digital Identity Act, as I mentioned, the DAO supplemented DAO, the DUNA Act, the Registered Digital Assets Act. And I would like to take a moment to provide some guidance in terms of a path forward that I think might be helpful for the committee to consider regarding the bill draft on digital ledger, the digital ledger filing system, because I think this might be useful, given the comments yesterday by Stephen Sprague and John Bitsky. I can't pronounce his name exactly.
Belitsky.
Belitsky, yes. And the topic of doing business as DBA as digital names, doing business as digital names. Okay, so we've been talking about this for a number of years. That idea of doing business as a digital name, that is the public identifiers that we've been talking about for 5 to 7 years, maybe 5 years to be more exact. And it has been stated that Stephen Sprague is using 0x addresses as representations of business names in Delaware. This is something that's happening right now just by registering that as the name field for a business. I've spoken to David Pope about this idea. We have talked about it, public testimony with Christopher Allen, that there are certain issues that need to be resolved in the way this is done. But, specifically, here's the problem. The problem is fundamentally what we're trying to do, and what was outlined yesterday with these DBA names, or public identifiers, as we've been calling them historically, is we're talking about two names for a company: a digital identifier name and a natural language name. And herein lies the problem. This is something, this is not a software problem. Okay, we don't need to build a digital ledger system, and we don't need to build all sorts of software in order to interact with the SOS database, because fundamentally that system exists. All we need to do is to specify with clarity legally how we deal with the idea that a company can have two names and the semantics around that. This is not a software problem. There's a tiny bit of software potentially around the interface. So it's not a software build problem. It's potentially a tiny little interface issue. A 13-year-old using artificial intelligence can write the software interface for this. It's not difficult. We now have at our disposal the DUNA. We created the DUNA as an entity. It is now effective as of yesterday as an entity which is designed and intended to allow for funding for protocol development, the exact thing that we're talking about. Representative Western has spoken yesterday and made mention of the fact that industry players would step in to write whatever is needed for this little tiny interface. This is not a problem which requires a whole lot of money. It's a zero cost problem. What it is a problem related to definitions legally of a business having two names. What is the order of those names? If you have a natural language name and a digital identifier name, does one come before the other? What's the representation? There are a few other issues here, but it really is not that complex in a first approximation. Now, I'll pause and I'll take a comment because I've been speaking a bit.
Mr. Co-Chair?
Thank you, Mr. Chairman. Brendan, are you suggesting in any way that there currently is a statutory problem with a DBA legally representing that corporation equivalently? Or do you see it as legally equivalent, or do you just not know and that's something we need to figure out?
Mr. Maher?
Oh, absolutely. So, there's no legal problem here for those who understand how to do this, right? Stephen Sprague said he's doing it in Delaware. I know how to do it. A handful of us know how to do this, okay? But there are problems in terms of this becoming widespread, right? To do this at scale for people requires some legal defining. And it comes down to a few issues, and we've spoken about this before. Christopher Allen has testified about this. What happens if you take the 0x address, and it's fine if people are doing this now with 0x addresses, blockchain addresses that are applied to ownership of equity of a company and representing that in articles of incorporation. There's no problem there. What happens is that when we take that 0x address and you're using that as brand identity, right? And that 0x address, which is based on a public key, and that key gets rotated, right? You swap out the keys for security reasons. Well, you just threw away your brand identity, right? You no longer call the Gap anymore, right? You're now a different digital identity address, right? So that's why I've been using the term the term public identifier, because it's not exactly a public address, right? Or if it is, you have to have some a little more legal clarity in terms of what that means and how that swapping occurs when you rotate keys and things like that. So there's one or two permutations around this. Okay, so there are some nuances, but I can tell you, right? While these things are not large, great problems, they're not something that's going to be solved by putting forth the problem in front of a number of university students. This is a problem that requires a deep understanding of the issues over a long period of time. There's only a handful of people in the world that know how to solve this. And they tend to hang around here with the committee. We know how to do this. It's not a software problem. It's a legal definition problem. And the reason why it becomes a problem is, and the way it could become a potential problem is simply understandable by this sentiment. If you have a digital identity name and a natural language name, well, legally, what do you use, right? Do you use both? Do you use one? Do you use the other? If you use both, well, what happens when you go to enter it in some entity's database and it doesn't fit? Because the programmer who wrote the field for that database only wrote it for 32 characters. Now what? Right? Business names or legal natural language names are usually not more than 32 characters, right? But these 0x addresses are longer than that. Now what, right? So it's not so much a problem of, can you do it legally? We can do this legally now. But to do it with certainty at scale requires some definitions in terms of how the world will interpret this. And if we do this, if we actually do this, we will change the entire internet. because we will change how identity works. It is so deep and so profound. And Christopher Allen has spoken about it. I have spoken about it. Stephen Sprague gave testimony of it yesterday, of the deep implications here, because underneath it, it's not just the representation of a name. It's the ability to take action, to attest to something, to prove something, to verify something. All of these things that we enabled with the Digital Identity Act by the way we wrote it. But we don't have clarity on how the world can understand this. And it's relatively simple, but it requires a background in understanding what the issues are. I hope that's helpful. I'll take more questions. Oh, and I have to add, sorry, Senator Ruffus, you asked me about it, what else needs to be changed, and of course it also goes back to, inclusive of this is the regulation on naming of series LLCs, right? Because that regulation, which is, I don't have it, I have it handy here somewhere here, but you know the one I'm talking about, the one that's on the books that deals with series LLC naming. Well, what happens then? You have a parent name for the parent entity, and you have a child name. So you have the 0x address, and then the natural language name, and then the 0x address of the child, and then the natural language name of the child. Right. So then now you're talking about, 2 0x addresses and 2 natural language names. Actually, it doesn't need to be that complex. When we actually work this out, that'll all go away. It'll be simpler, right? But the other thing, and I've spoken to this before, and this is the other third problem. It's not hard. But when you speak about these things, these 0x addresses, it's all relative to a specific blockchain, right? So which blockchain you're talking about? You have the 0x address, but you don't have a specification of which chain it's on. Now, sometimes, that's often interpretable by the blockchain itself.
Brendan,
as they grow. Yeah.
Brendan, let's
you get my point.
For
You get my
just a
point.
sec. I think Co-Chairman Rothfuss might have a comment or a question. So let's just take
Sure.
that real quick. Where's Co-Chair?
Thank you, Mr. Chairman. And Brendan, I appreciate this analysis. As we look at it from the legal and statutory standpoint, going back to the original question, it does seem to me that right now the DBA system that was suggested by Mr. Sprague is compliant with Wyoming statute. This is something, honestly, we can and should follow up with the Secretary of State's office on and make sure that would be an allowable DBA. So we'll do that as a 0x address. But getting back to your key rotation and the concern that you provide, from a legal standpoint, the way we use natural names is once it goes on the books, that's yours protected. If somebody else tries to file for it, you're going to keep it, they'll reject it. And so you have some legal standing of using a natural name. And then the same thing would take place with a DBA if somebody tried to use the same 0x address that you were using. There would be a rejection of that. They wouldn't be able to use it for any practical purpose, but they could still try and it would be rejected. The concern, though, with key rotation is a real one. We would not want an address as the primary, so to speak, in the database, the identifier key that you're going to use as your 0x address having dominance, because the expectation would be that you would be rotating out that address at some point for security purposes. And even though it then wouldn't get used again, maybe it stays on file in some way, that would be a deprecated 0x address and you would move to a new one. Ironically, or perhaps just conveniently, the system we have in place right now with a DBA would allow for that. You would terminate one DBA and you would initiate another DBA. And in fact, you might even initiate 3 different DBAs for the same company with 3 different key addresses that would all be public keys associated with 3 different blockchains. So it almost seems like the system right now, by pure coincidence, actually allows for everything you just described, where the dominant data entry point is going to be the plain language name under the current system, and all of the DBAs would be subsidiary to that, but still have legal equivalence. So they would be authoritative from a legal standpoint on an or basis. You could use plain language, or you could use DBA1, DBA2, DBA3, which could all be 0x addresses. That seems like the vision that you're laying out as being the desirable system. It seems to me that, again, by coincidence, it already does that. Do you see anything specifically that doesn't allow for that, or what is the system missing that it should have in the near term? Again, we'll improve upon this when we create the registry system if we get there. But in the near term, what is from a legal standpoint missing?
Mr. Maher, go ahead.
Sure. Well, from a legal standpoint, well, that actually is a very good, logical train of thought there, Senator Rothfuss, that you could use the, natural language name as existing, and these other names as needed. From the legal standpoint, I guess the question becomes, do you need to use both? So what you're saying is you would use one or the other, and you would never be needed. You would never be required to put both together, which that might be plausible. To get to your question regarding functionally, how does this actually work with what we have? If you take that into consideration, maybe I'd have to think further about that. I don't want to, on the spot, I don't want to say yes or no to that, but I do want to get to the area where it completely breaks and does not work, right? It does not work in the case of us just simply not having the ability to have the interface to be able to do that, right? The telephone doesn't work, right? It's not going to, it's okay when you go to, construct a company, you create a company and you call up your registered agent and you say, okay, I'm going to start a company. And then, the company is created, the Secretary of State creates the file number, and it's just done once, right? And when you do a DBA change, if you do that, you do that maybe like once or twice in the lifetime of the company. We're talking about something that happens, much more frequently here, and needs to be able to be done at scale, and can't be done over the telephone, and can't be done by, using mail, which I think it's the case that you still have to use, snail mail and wait 2 weeks to change your company name. If I remember, that's still in place. So these things don't work, and they're certainly not going to work for the DUNA, right? We constructed the DUNA, and we know that when the DUNAs get rolling, that there's going to be an administrative agent, and that administrative agent for the DUNA is going to, make these filings, and the things that they're filing on the other side of the wire is going to be an entity which is completely functioning in software online, right? Because the whole organization is online. So there needs to be, that
Mr. Maher, I think,
Interface,
my
interface, yeah.
co-chairman I think my co-chairman wanted to just add on to that real quick. Mr. Co-chair?
Yeah, okay.
Yeah, thanks. Thanks, Brendan. I
Sorry,
appreciate that.
you're
And
small. I
so
can't see you, so.
Yeah, no worries. And Mr. Barr, so what it sounds like, and I appreciate that, is that from a legal standpoint, we're actually positioned oddly, and again, by coincidence, reasonably well. But from a logistical and operations standpoint, that's where we're going to run into some barriers, and that makes good sense. It does seem consistent with our efforts on the digital ledger side to try and advance this, and again, incorporating the types of tools and capabilities of scale up where we can be doing this digitally through API, have the capacity for rapid key changes at any point in time. I agree. I think that's all essential. Mr. Co-Chairman, I see that Mr. Pope actually has his hand up also.
Sure.
Mr.
And
Barr,
one
let's-
kind of-
Mr. Pope?
Mr. Pope needs a quick question. Yep.
Yep, go ahead, Mr. Pope.
Thank you, Mr. Chairman, and thank you, Mr. Marr. In my only real comment on this is that in our last meeting, Mr. Marr and I were assigned to a working group on the digital commercial registered agent. And I believe that concept could play a big part in this scenario here, because the digital commercial registered agent could always be the collection point for those changes and the monitoring of the current status of those. But that is something that I would love the opportunity to comment further on our direction in that later on after we're through discussing this particular concept.
Well, thank you very much, Mr. Pope, and Mr. Maher. I was generally following what you were saying, but you know, it is about 3:30 and our staff does have to drive back to Cheyenne tonight. So they're looking at, I want to try to get them back at a semi-decent time. And I know we've got some committee members that also have got a long drive in their hands, but I really do appreciate your passion on this topic. And I think there's a lot that's worth exploring. I just don't want to keep our staff here for another, 2-3 hours and force them to,
Great.
drive back. So if it's okay, I was wondering maybe if we can maybe put this on the agenda for next go round.
If I make 2 tiny comments to close out.
Mr. Martin, go for it. You can wrap us up.
Wonderfully. I appreciate that. Thank you so much. The 2 comments are, first and foremost, I want to say I stand corrected on what I said to Senator Rothfuss. I actually don't think it works from a legal standpoint, because ideally what we want to be able to do is be able to represent both the natural language name and the 0x address. Because, quite frankly, if you're not a geek, you just don't like hexadecimal or anything else. So we really need to figure out how to be able to represent both simultaneously. And to David Pope's comment, yes, what I'm putting forward is that my recommendation for the committee is that they, do have a working group for these issues, and the working group would be specifically focused on doing business as digital names, and that could be the working group for the commercial registered agents. But the focus really is resolving this aspect here of doing business as digital names. That's my comments, and I do hope that it is constructive.
Thank you, Brendan. I do really appreciate that. Again, I think there's no question that there's at least some merit here that's worth probably doing a deeper dive into at some point. Let's see if there's any other general public comment in the room. Not seeing any. Is there any else online? Clarissa, are we not seeing any? Okay, let's go ahead.
I think Mr. Pope also, didn't he say he wanted to say something at the end?
Or Mr. Pope, was there something else you wanted to toss in there real quick?
Thank you, Mr. Chairman. No, I think Mr. Marr adequately said that I would like a us to consider a functional working group around the concepts. And, I had originally thought that a digital commercial registered agent type concept would be a great working group. I think we can expand that. I have not been a part of a working group prior, so I don't know what the parameters are, how to effectively administer one of those, whether we would need help from the LSO. So I would need some guidance that you can certainly provide me offline on that if we have that working group. And also, do we need at least one legislator to be part of that working group? So just questions in that regard. I would love to get moving on it. I just had no real idea how to, again, administer or manage that type of thing. And you can certainly get back with me offline if we choose to move in that direction.
So this is kind of what I'm thinking. Again, given the late hour, but also that there's some merit to this topic. I'm going to appoint a functional working group consisting of Mr. Pope, Mr. Maher, and Representative Singh. You are being voluntold, as they say in the biz. So I'll let you guys convene, coordinate with each other, Mr. Maher, Mr. Pope, on getting together and trying to get some direction on this one. Mr. Co-Chair, did you want to weigh in a little bit?
Yeah, Mr. Chairman, I think that's a good approach, and Representative Singh can chair that working group with the two of them. Maybe there's some others that need to join and work with staff on putting together a Zoom meeting. And Mr. Chairman, really probably over the next 2 weeks, we need to get these things started. One of the struggles we had during this last interim was we had so much, we ended up getting some of this work going too late and not having
did.
time to really put together products. So I'd really encourage this time between now and next interim for us to get our working group meetings started within the next 2 weeks for the first meeting, so that if we do have anything that's coming out of those meetings, we have time to work it through. And so I appreciate that suggestion. Appreciate, Mr. Pope, your willingness to serve on that, and Representative Singh, your willingness to serve on that as well.
Excellent. So I think with no further objection, the last component is of course committee directives. So before I jump the gun a little bit, Mr. Hopkinson, could you maybe we could review some of the directives we've gone over the last 2 days?
Certainly, Mr. Chairman, and I'll just kind of talk about what the committee's done. So first off, they did vote to sponsor 25 LSO 81, Secretary of State expedited filings as amended. Voted to send 25 LSO 28, Special Purpose Depository Institution amendments on to minerals, splitting that draft in two. We'll carry forward 25 LSO 86, Digital Ledger Filing System Development with amendments. Carrying forward 25 LSO 71, Select Committee on Blockchain and Emerging Technologies with amendments. We'll be drafting 2 versions of Senate File 51, the misleading unlawful distribution of unlawful synthetic media, to bring forward to the next meeting. One for kind of general, pretty similar to what we already have, and then another specific to campaign laws. Carrying forward 25 LSO 90, Defense of State Banking with amendments. Carrying forward 25 LSO 88, Data Privacy Government Entities. And then there was a few working groups that were discussed. One, a UEDA working group as a possibility. From the last meeting, there was still the name, image, likeness working group, with commercial registered agent working group. And then we had just described a functional working group with that topic just discussed. I don't know if you wanted to overlap that with the commercial registered
That's the
agent
commercial registered agent.
or just make that. Okay, so that would be the commercial registered agent group. And then we'll be looking into adding kind of the biological data concepts into personally identifiable information concepts. I'll work with Chairman Rothfuss on that. And then there was also discussion of perhaps kind of facilitating a working group with Speedies and the Wyoming Business Council to see what could be done there. That is what I have as far as previous discussions. If I missed anything, please let me
Mr.
know.
Hopkinson, I think that pretty much covers, I think what we did touch on. You know, for the speedy working group, I guess we didn't quite fully ascertain if Ms. Fellows or if, you know, Mr. Goldberg's, you know, bandwidth to be on something like that. Mr. Co-Chairman, do you want to weigh in?
Yeah, Mr. Chairman, on that one, I don't know that it'll be that much of a working group so much as just a meeting and see how things go. I think for that one, let's schedule a meeting within the next 2 weeks with the Speedy Banks, the Business Council, Mr. Goldberg, and, you know, I'd like to be on that meeting. I don't know if you would or
Sure.
anyone else would, but we
Yeah.
could, Mr. Hopkinson, survey the committee, see who would like to join that, but definitely our Speedy
Our chairs.
Banks and the Business Council, and let's have that conversation in more detail on what we can do to achieve that outreach objective.
Yeah, I think definitely putting the chairs in, that's probably appropriate. I think that's pretty much it, absent any objections or concerns from the committee members.
Anything else that,
Yeah.
I don't
anything
know
else?
if anyone online has anything.
Anybody online? Anything else for the good of the order? All right, well, seeing none, this meeting is adjourned. We will see you all in
Yep.
September.
Let's see what those dates are real quick.
Yeah,
So
yeah, for
we
the
are
17th.
meeting. We are meeting September 16th and 17th, Mr. Chairman,
In
at
Wyoming.
University of Wyoming. That'll be part of the Blockchain Stampede Week. So there will be the Blockchain Stampede, associated hackathon, and everything else we typically do at the University of Wyoming. We'll be meeting in co-library room 506. And as always, there'll be the opportunity to Zoom in
Sure.
for public testimony if need be.
You'll be hosting us.
I will
Mr.
be
Co-Chairman.
hosting. We'll have the students back in town, so it'll be a great,
Lively.
a few great fall days in Laramie, Wyoming. Look forward to seeing you all there.
Could be either 80 degrees or fighting through snow. Who
We
knows?
don't know,
We don't
and we
know.
won't know until the day before.
Great mysteries of life. This meeting is adjourned. We'll see you all in Laramie.